Before we dive into what may be the most significant development in the disappearance of Lilly and Jack Sullivan, make sure you're subscribed to the channel and hit that like button. What Daniel Martell told the RCMP after his arrest has shocked investigators and could change everything we know about this case. Let's examine what was said, the context of the arrest, and what it means for the search for truth. On January 26, 2026, the investigation into missing Sullivan children took a sharp and unexpected turn. Daniel Robert Martell, the 34-year-old stepfather of Lilly and Jack, was taken into custody at 11:30 a.m. He wasn't charged with the disappearance of the children. Not yet. Instead, he was charged with assault, sexual assault, and forcible confinement involving an adult victim. While authorities officially stated these charges were unrelated to the missing children, the timing and the nature of the arrest sent shockwaves through the community. But what happened after the handcuffs clicked shut? What did Daniel tell investigators during those high-stakes hours in an interrogation room? To understand the significance of any statements Daniel made, we first have to understand the rigid legal framework of custodial interrogations in Canada. When someone is arrested, they are immediately shielded by the Canadian Charter of Rights and Freedoms. They have the right to be informed promptly of the reasons for their arrest and the right to retain and instruct counsel without delay. Most importantly, they have the fundamental right to remain silent. These are not just procedural formalities. They are the bedrock of the justice system, designed to prevent the abuse of state power. When Martell was processed, the police were legally required to inform him that anything he said could and would be used as evidence against him. At that moment, Daniel faced a critical crossroad. He could invoke his right to silence and refuse to speak until a lawyer was present, the advice any defense attorney would give in their sleep, or he could choose to speak. Sources close to the investigation indicate that Daniel did not stay silent. He chose to talk. The question that haunts this case is, why? Was it an attempt to control the narrative, or did the pressure finally break his resolve? Interrogators have specific goals when they sit across from a suspect. In Daniel's case, they weren't just looking for a confession regarding the assault charges. They were looking for a bridge to the Sullivan case. Even though the charges were technically separate, Daniel was a primary figure in the lives of Lilly and Jack. He was one of the last people to see them alive. He lived in the house they vanished from. This made him the most relevant person in the room. While investigators can legally ask about the missing children during an interview for other charges, the suspect has no obligation to answer. Yet, reports surfaced that Martell's statements were shocking. In the world of criminal justice, shocking isn't a word used lightly. It implies something unexpected, something disturbing, or something that fundamentally shifts the foundation of the case. While we must distinguish between confirmed facts and speculation, the official confirmation remains limited. We know he was arrested. We know he was released with conditions pending a March 2nd court date, and we know the RCMP found his words significant enough to leak that characterization to sources. If Daniel spoke about the children, we have to consider what would qualify as shocking. A direct confession is the most obvious, but also the most rare. Suspects who have had 9 months to calculate their story seldom walk into a room and hand over a full admission of guilt. More likely, shocking refers to admissions that indirectly implicate him or reveal reality inside the home that contradicts everything he and the children's mother, Malaya, have said for nearly a year. This is where the investigation stands today, balancing on the edge of a revelation that could finally tell us where Lilly and Jack are. As we analyze the potential content of Daniel Martell's shocking statements, we have to look at the cracks in the existing story. If Daniel provided a new timeline of the events of May 2nd, 2025, it would be a massive development. For 9 months, the public has been told a specific sequence of events. Lilly was seen moving in and out of the bedroom, and Jack was heard, but not seen, playing in the kitchen. If Daniel's post-arrest statements changed who saw whom and when, it would suggest the original story was a fabrication. Truthful accounts of trauma usually remain consistent in their core facts. When a timeline shifts after 9 months, it's often because the speaker realizes the old lie no longer fits the evidence. There are several scenarios that would be characterized as shocking in this context. First, did Daniel admit to being the last person to see Jack alive? If his new account differs from his original statement, Investigators would immediately want to know why he waited nearly a year to correct the record. Second, did he admit to a level of conflict or violence in the household that was previously hidden? Any admission that he lost his temper or that there were physical altercations involving the children would be a pivot point for the RCMP. Third, and perhaps most disturbing, is the possibility that Daniel admitted to altering the scene. If he confessed to cleaning up evidence or moving items after the children vanished, it would demonstrate what the law calls consciousness of guilt. It would prove that he knew something happened and took active steps to hide it. Fourth, did he provide speculatively new information about their whereabouts? Even if he didn't confess to a crime, suggesting new search areas or mentioning locations the children supposedly liked could be a tactical move to appear helpful while still leading police to a grim discovery. We must also consider the possibility that Daniel's statements contradicted Malia's account. In any investigation involving two adults in a household where children go missing, contradictions are the gold mine for police. If Daniel points a finger or describes a different reality than the one Malia has maintained, it creates a wedge that investigators can exploit. Furthermore, if Daniel admitted to the domestic violence that Malia alleged in her May interview, it would corroborate her claims and establish a clear pattern of violent, controlling behavior. This brings us back to the assault charges he currently faces: assault, sexual assault, and forcible confinement. These are not just random charges. They reveal a specific psychology. Forcible confinement, in particular, suggests a desire to control and trap another human being. When you apply that behavior to a household with two small, vulnerable children, the implications are terrifying. Children in such an environment have no escape and no way to defend themselves. The presence of sexual violence in a home, even if directed at an adult, exponentially increases the risk to every minor under that roof. While there is no public evidence of sexual violence toward Lilly and Jack, the capacity for such acts reveals a dangerous individual. The word shocking also suggests that Daniel might have revealed a lack of empathy or a calculated manipulation that investigators hadn't fully assessed. If he spoke about the children with a coldness or a level of detail that only a participant would know, he would be demonstrating guilty knowledge. This is a powerful tool for the prosecution. If a suspect knows the specific color of a missing child's clothing that was never released to the media, or knows a detail about the state of the house that only the police and the perpetrator could know, their innocence becomes an impossibility. The strategic question for the RCMP now is how to use these statements. Do they charge him now, or do they wait to gather more physical evidence? The public pressure is immense. Pictou County and the rest of Canada are desperate for answers. But justice cannot be rushed. A case built on words alone is vulnerable in court, especially if a defense lawyer later claims those words were coerced or that the suspect was confused due to the trauma of his arrest. Every detail Daniel gave is now being checked against 54 witness interviews, hundreds of hours of surveillance, and digital forensics. The truth is somewhere in the gap between what Daniel said then and what he is saying now. The interrogation of Daniel Martell was not a random conversation. It was a high-stakes psychological battleground. When we hear that his statements were shocking, we must look at the sophisticated techniques employed by the RCMP to extract that information. Modern Canadian law enforcement has moved far beyond the era of crude intimidation. Instead, they use evidence-based psychological principles designed to lower a suspect's defenses and encourage them to speak, even when it is not in their legal best interest to do so. One of the most effective tools in the investigator's kit is the building of rapport. In the hours following his arrest on January 26th, investigators likely presented themselves not as enemies, but as non-judgmental listeners. They wanted Daniel to feel that they were the only ones who wanted to hear his side of the story. This creates a false sense of security, where a suspect feels they can explain away their actions. Closely tied to this is the technique of minimization. Here, an investigator might suggest that Daniel's alleged violence toward an adult victim, or even his potential involvement with the children, was an understandable mistake, a moment of snapping under pressure, or a reaction that anyone in his shoes might have had. By framing monstrous actions as human errors, they give the suspect psychological permission to admit to them. However, the shock likely came from the opposite direction, the confrontation of evidence. The RCMP had been building this case for 9 months. They didn't walk into that room empty-handed. They had surveillance footage, cell tower pings, and nearly 60 witness statements. When Daniel offered a narrative, investigators were ready to point out every inconsistency. This is where the cracks form. If Daniel claimed he was in one place, and the police showed him data proving he was in another, the resulting explanation often reveals more than a confession ever could. This is a moment where guilty knowledge often slips out, a detail about a crime scene or a specific event that an innocent person simply could not know. We also have to consider Daniel's own unique psychology. Throughout the 9 months since Lilly and Jack vanished, he has been a public figure. He has appeared on television, spoken to the media, and presented himself as a grieving, concerned stepfather. This behavior suggests a man who is comfortable with deception and who believes in his own ability to manipulate public perception. Such individuals often fall into a trap during interrogations. They believe they are the smartest person in the room. They think they can talk their way out of a murder investigation, just as they talk their way through a news interview. But the stakes in an RCMP interview room are infinitely higher, and the listeners are trained to spot the micro-expressions and verbal fillers that signal a lie. The characterization of his statements as shocking implies that Daniel may have shifted from his role as the concerned protector to something much darker. Did he reveal a capacity for coldness? Did he discuss the children with a lack of empathy that disturbed even seasoned investigators? Criminal psychology tells us that abusers often have a public face and a private reality. If the statements Daniel made after his arrest finally bridged the gap between those two personas, it would explain why sources describe the interaction as significant. Furthermore, we must look at the possibility of a partial admission. It is a common tactic for a suspect to admit to a lesser sin to cover a greater one. Perhaps Daniel admitted to a heated argument on the morning of May 2nd, or perhaps he admitted to being neglectful in a way that led to an accident. While these aren't full confessions to a crime, they are shocking because they destroy the original, pristine narrative he provided in the early days of the search. They provide the hook that investigators need to pull on the rest of the thread. As we move closer to the March 2nd court date, the legal team for Martell will undoubtedly be working to suppress these statements, knowing that the shock they cause investigators could easily turn into a conviction in front of a jury. The legal aftermath of Daniel Martell's statements is a complex maze of Canadian constitutional law. While the public wants immediate answers, the judicial system moves with deliberate, sometimes frustrating, slowness to ensure that the process is airtight. If Martell's shocking statements are to be used in a future trial regarding Lilly and Jack Sullivan, they must first pass the rigorous test of admissibility. This is where the battle between the prosecution and the defense truly begins. In Canada, a voir dire, a trial within a trial, will likely be held. During this proceeding, a judge will listen to the recordings of the interrogation and hear testimony from the arresting officers. The defense will argue that Daniel was coerced, that he didn't fully understand his right to silence, or that the shocking nature of the statements was a result of psychological pressure that overbore his will. If the judge finds that his charter rights were violated, those statements could be excluded entirely. However, even if the words themselves are barred from the courtroom, the fruit of those statements, such as physical evidence discovered because of what he said, might still be allowed. This is a critical distinction. If Daniel told police where to find a piece of clothing or a hidden item, and they found it, that physical evidence often speaks louder than the statement that led to it. The strategic timing of his arrest on January 26, 9 months after the disappearance, also plays a role in the legal drama. 9 months is a long time for a story to sit in a suspect's mind. The prosecution will argue that any change in Daniel's story now is a sign of recent fabrication or a crumbling alibi. Conversely, the defense might argue that his memory has simply faded or been clouded by the trauma of being arrested for unrelated assault charges. But as investigators know, people don't forget the last time they saw their children. They don't forget the details of the morning their lives changed forever. If Daniel's story is shifted, the law views that shift with deep suspicion. We also have to consider the possibility of a plea deal, though this is a controversial path. In many high-profile cases, prosecutors may offer a suspect a reduced sentence on one set of charges in exchange for the truth about another. Could the Crown offer Daniel leniency on the assault, sexual assault, and forcible confinement charges if he provides the exact location of Lilly and Jack? This creates an ethical minefield to the victim of the assault. Such a deal might feel like a betrayal of their suffering, but to a community and a family desperate to bring two children home, it might be the only way to find resolution. These are the deals of the devil that sometimes define the end of a missing persons case. The March 2nd court date is the next major milestone. This appearance will likely set the tone for the coming months. If the prosecution files additional charges before this date, it is a clear sign that Daniel's shocking statements have been corroborated by physical evidence. If no new charges are filed, it suggests that the RCMP is still in the verification phase, painstakingly checking every name, location, and event Daniel mentioned. For the family of Lilly and Jack, the legal technicalities are secondary to the emotional reality. They have lived for 274 days without knowing if their children are safe, if they are cold, or if they are ever coming back. To them, a shocking statement is only valuable if it ends a waiting. Justice in this case has two faces: the punishment of the guilty and the recovery of the missing. If Daniel's words only lead to a prison sentence for assault, but leave the fate of the children a mystery, the shock will eventually fade into a lingering, unresolved pain. As we continue to follow the developments out of Pictou County, we must remain focused on the facts. The arrest of Daniel Martell has opened a door that was closed for nearly a year. Whether that door leads to a courtroom, a confession, or the final recovery of Lilly and Jack remains to be seen. What is certain is that the investigation has entered a new, more aggressive phase. The silence has been broken, and the shocking revelations of January 26th have set a clock in motion that cannot be stopped. To understand why Daniel Martell's statements were characterized as shocking, we must look beyond the man himself and examine the ecosystem of people surrounding him. In a case of this magnitude, the truth rarely exists in a vacuum. It is buried under layers of family loyalty, fear, and shared secrets. One of the most significant figures in this web is Daniel's mother, Janie McKenzie. For months, Janie has been a vocal supporter of her son, providing the crucial alibi that the children were seen play on the swings on the morning they disappeared. If Daniel's post-arrest statements implicated his mother, the impact would be devastating and would fundamentally change the investigative focus. Scenario-wise, if Daniel revealed that Janie knew more than she initially told investigators, or that she helped him cover up his movements, it would explain why the word shocking was used. Implicating one's own parent is a rare and desperate move in an interrogation. It would suggest that the pressure of the assault charges broke the bond of family silence. If Janie was involved in creating a false alibi, the RCMP would need to determine if she was a willing participant or if she, too, was a victim of Daniel's documented pattern control and intimidation. This leads us to the possibility that Daniel's statements revealed a domestic environment far more toxic than the public ever realized. Then there's a relationship between Daniel and Malii, the children's mother. The investigation has always been haunted by the inconsistencies between their two accounts. If Daniel's shocking statements involve a shift in blame toward Malii, it would create a nightmare scenario for investigators. Suspects often attempt to deflect guilt by painting the other adult in the house as the unstable or violent one. If Daniel claimed that Malii harmed the children and he was merely a witness or an accessory after the fact, the RCMP would be forced to re-examine every piece of evidence through a new lens. However, given the assault charges Daniel currently faces, his credibility in accusing others of violence is an all-time low. Investigators are trained to see through blame shifting as a standard deflection tactic. Another shocking possibility involves the identity of the adult victim in the assault case. If this individual is somehow connected to the Sullivan children, perhaps a former babysitter, a neighbor, or a secret witness, the assault itself might have been a silencing act. If Daniel's statements revealed that he attacked this person specifically to keep them from going to the RCMP about Lilly and Jack, the two cases would merge into one. This would explain the shock felt by investigators. It would mean the key to the children's disappearance was hiding in plain sight within a seemingly unrelated domestic violence file. Furthermore, we must consider the darker psychological revelations that might have emerged during the questioning. If Daniel discussed violent fantasies or a lack of remorse, it would provide a chilling profile for the prosecution. Statements that reveal a sociopathic disregard for human life are rare, but deeply impactful. If Daniel spoke about the children as obstacles or burdens rather than as family, it would confirm the worst fears of the community. This kind of revelation doesn't just provide facts. It provides motive. It helps a jury understand how a man could live in a home for 9 months while knowing the terrible truth of what happened to the two innocent souls who once lived there. As the RCMP processes these leads, they are also looking at the digital footprint that accompanies these statements. Every location Daniel mentioned is being cross-referenced with his cell phone pings from May 2025. If he mentioned a location he previously denied visiting, and the digital evidence now supports his new story, the investigators have moved from suspicion to proof. This is the painstaking work that happens behind the scenes. The shock of a statement provides a spark, but the evidence provides a fuel for a conviction. Every subscription, and like on this channel, helps US continue to shed light on these developments, ensuring that the names of Lilly and Jack Sullivan are never forgotten as we move toward the final truth. 9 months and 24 days. That is the agonizing count for the family of Lilly and Jack Sullivan. It is a timeline marked by empty bedrooms, silent playgrounds, and a relentless search for answers that always seem just out of reach. The arrest of Daniel Martell and the subsequent shocking statements represent the most significant movement in this case since the children vanished on May 2nd, 2025. But as we conclude this analysis, we must ask, what does resolution actually look like in a case this complex? For the community of Pictou County, resolution is often equated with a confession. There is a collective hope that Daniel will simply sit down and tell the truth, providing the location of the children and an explanation for the inexplicable. But the reality of criminal justice is rarely so clean. Even if Daniel's statements were significant, they may not lead to an immediate recovery. If his shocking revelations were about his own patterns of violence or his deceptions regarding the timeline, the investigation may still have miles to go. The RCMP is now in a race against time and memory, trying to find physical proof that can withstand the scrutiny of a high-profile trial. The upcoming court proceedings on March 2nd will be the next major turning point. This is where the shock of the interrogation room meets the cold reality of the courtroom. The public will be watching for any sign of additional charges. If the Crown proceeds solely on the assault and sexual assault charges, it suggests that while Daniel's statements were shocking, they were not yet enough to prove homicide beyond a reasonable doubt. However, if new charges related to the children are brought forward, it will mean the RCMP has found the smoking gun, the physical corroboration of Daniel's words. We must also prepare for the possibility that the truth is more painful than the mystery. Shocking statements often lead to grim discoveries. If Daniel provided information that suggests the children are no longer alive, the mission changes from rescue to recovery and justice. This is a heavy burden for the family and the investigators to carry. Yet, as many victims' advocates argue, a painful truth is often better than a permanent lie. Knowing what happened allows for a different kind of mourning, one that isn't interrupted by the agonizing what-ifs that have defined the last 9 months. The broader implications of this case extend to how we handle domestic violence and child protection. The charges Daniel faces, assault, sexual assault, and forcible confinement, are a stark reminder of the dangers that can exist behind closed doors. If these charges are the key to unlocking the mystery of Lilly and Jack, it highlights a failure in the systems meant to protect the vulnerable. The fact that it took an unrelated arrest to generate a breakthrough is a sobering thought. It suggests that the answers were always there, hidden under the surface of a violent household, waiting for the right pressure to be applied. As we wait for the March court date, the commitment to this case remains unchanged. We will continue to analyze the facts, filter out the rumors, and provide a platform for the truth. The Sullivan children, 6-year-old Lilly and 4-year-old Jack, deserve nothing less than our total dedication. They cannot speak for themselves, so the evidence must speak for them. Daniel Martell's words in that interrogation room may have been shocking to the RCMP, but the ultimate goal is to ensure that the final pieces of a puzzle that brings justice home. If you have any information, no matter how small or seemingly insignificant, regarding the events of May 2nd, 2025, or the movements of Daniel Martell and Janie McKenzie, please contact the RCMP immediately. Your tip could be the one that turns a shocking statement into a definitive answer. Thank you for following this comprehensive 6-part examination. Stay informed, stay engaged, and join us as we continue to follow the evidence wherever it leads. The truth for Lilly and Jack is out there, and day by day, we are getting closer to finding it.